I'm going to be talking about some of the legal landscape. I have to tell you this, that all things disability are my passion. I've been a disability rights lawyer for...
Maybe I can help you put it
Thank
on.
you.
Okay.
Sorry, I keep on dropping it.
Oh,
Big loud in your...
Oh, it's not coming down like that. Oh, it's the other way.
Excuse us.
All right.
So all things disability, all things access are my passion. I've been a disability rights lawyer for 40 years. Was really there at the beginning. I like the reference to curb cuts that someone made. It's one of my favorite things that I kind of stuck into the ADA. And I'm also a user of captions. And so among all the various disability issues of which I'm passionate, I could say maybe I'm the most passionate, although that's a tough competition, about captions. So this is what I'm going to be talking about today, basically what the legal bases are very, very quickly. Some of the cases that we've been bringing are how we go about reaching resolution on cases and some of the other applications besides the ones that I'm doing. All of what I'm going to be saying about the law is also applicable to access for people who are blind and visually impaired. I'm going to be using my time to primarily talk about captions because those are most of the cases that I've done. I've also done cases about visual impairment for instance, the Social Security Administration that sent out notices to people who got benefits on the basis of blindness in regular print. And when we first got that case, this is a case we did a few years ago. When we first got that case, we were like, oh, this is like a Saturday Night Live skit. You know the person's blind and you send them their benefit letters in regular print that say, if you don't respond in 10 days, you lose all your benefits. So we thought, we're gonna settle this case really quick. It didn't settle at all. It went all the way through a trial. So, like I said with the caption issue, and like I'll be saying as we go along and describing some of my cases, it's always amazing to me why this isn't kind of just basically common sense. And in a lot of situations, the raking up of attorney's fees, that choice could be much better spent in a commitment to access. So the basic laws that we work with, Americans with Disabilities Act, I have a feeling everyone here has heard of that, and Section 504 of the Rehabilitation Act, which is actually enacted in 1973. The regulations were in 1977. 504 of the Rehabilitation Act covers all recipients of federal financial assistance and non-discrimination on the basis of disability. It was the grounding, the foundation on which we built the ADA. And it comes into play, as you'll see, in some of the cases we now have against universities. Basically all receive federal financial assistance. And the ADA covers all governmental entities as well. So governmental agencies are covered. That's Title II of the ADA. And that's basically the same as 504, Section 504. It's the ADA's Title II's predecessor, except that 504 requires the receipt of federal financial assistance, and the ADA covers all governmental entities regardless of the receipt of federal financial assistance. And then there's Title III, of course, of the ADA, which covers private businesses, and that's the provision that we've used for Netflix, et cetera. There's a lot up here, and I want to be sensitive to the fact that some people cannot read it, so I'm going to actually read it out loud. The provisions we rely on, non-discrimination, includes more than prohibiting outright exclusion, segregation, and prejudice, but also requires the removal of physical and communication barriers. And in particular, Title III of the ADA defines discrimination to include providing a benefit, good, service, privilege, or advantage that is not as effective as what is provided to others. So we're really looking, when we look at communication access, we're looking at something that is as effective. And as the speaker before me was trying to illustrate, but I think you all probably have the experience of putting on the auto captions that Ken is brilliantly put together. But you know, they can be pretty funny. I mean, or sad if you really want to get the content. In addition to barring the discrimination, discrimination also includes not taking the necessary steps to ensure that people are not treated differently or lesser because of the existence of communication barriers, and it requires the provision of auxiliary aids. Auxiliary aids and services include effective methods of making orally delivered materials available to individuals with hearing impairments. And of course, an interpreter, sign language interpreter would be an example, but so is closed captions. So all of this is basically very, very explicit in the law. As you just heard, there's 48 million individuals who are deaf or hard of hearing. That alone would make you think that there'd be a big interest in providing captions, because that's a lot of people. But as we've learned and as the studies show, captions benefit so much beyond people who are deaf and hard of hearing. It's a great tool for English as a second language learners. It's a great, so many people have said that they use it because their babies are sleeping. There are so many reasons why people use captions. It's just socially, if I go and I talk about what I'm doing and I talk about captions, usually almost everyone at the table that I'm seated at, whether without hearing impairment, say, oh, I use captions. Captions are a great tool. And it was very good to get this additional information, the slides in the presentation before. So in terms of, I'm going to start talking primarily about Title III of the ADA. And Title III of the ADA was written to cover private businesses. And there's some really interesting stories about how the definitions were developed back in the day when the ADA was being developed. But leave it to say that basically there's 12 enumerated categories of public accommodations, and it was done basically, you know, with like negotiations between the White House and the Senate, where we were like looking at the yellow pages. What are all the various kinds of things that people access in their communities? And the list includes, and just to be, again, I'm summarizing, inns, hotels, motels, restaurants, bars, motion picture houses, theaters, concert halls, auditoriums, convention centers, bakeries, grocery stores, laundromats, terminals, zoos, parks, nurseries, daycare centers, gymnasiums, healthcare, education establishments. Basically, we were trying to cover the categories of every place anyone would ever have the need to go. What's interesting and most important from the legal perspective is that despite brief after brief after brief after brief that we are constantly seeing from opposing counsel in many of these cases, when they say that, you know, whatever we're suing about doesn't fit into one of those categories, we're always able to show that, let's just take 4. An auditorium, convention center, lecture hall, or other place of public gathering. And almost every single category has that at the end of it, where it says, or other place of entertainment, or other place of education. So it's never specifically only the places that are listed. It's meant to be illustrative. So for instance, number 9, a park, zoo, amusement park, or other place of recreation, and so on and so forth. So basically, I would say that Title III of the ADA covers any place that you, as a person in your society, in your community, would want to go, chances are that it's covered by the ADA, and Title III of the ADA in particular. Okay, why was Netflix a game changer? When Netflix came onto the scene, it was, I don't know how many of you remember, but it was revolutionary. It revolutionized entertainment to your home, that you didn't have to rush out to the movies, that you could watch at home, that you could watch while your babies are sleeping, you could watch just because you're a homebody like me. You could watch in your home, but you could also, as you were saying, you could take it with you wherever you want to go. And that was the big thing they sold when Netflix came on the scene. It was selling that you can have entertainment anywhere, any place. And the Netflix case, which I did have the privilege of bringing and arguing, was the first case to hold that an internet-only business was covered by the ADA. So Netflix came onto the scene, and we did have to go to court. We tried to negotiate. We always try to negotiate first. It's only when negotiations fail that we file lawsuits, and then we still try to negotiate. So Netflix said, well, first of all, there's no place of public accommodation. Where's the place? Netflix doesn't have a place. A movie theater is a place. A bakery is a place. A university is a place. There's no place. And so the biggest hurdle and the most important part of that case was saying that the internet is a place. And not only is it a place, but it's a place that falls under many of the enumerated categories or other place of entertainment. If it's an age thing. If you ask anyone under the age of, I don't know, 40, they have no doubt that the internet's a place. It's a place where they go to seek entertainment and to do a lot of retail and to do a large degree of their interactions with the community and with others are on the web. They also argued that, but wait a minute, that's like, we're going back to like, the whole point of the ADA was places in the community, a bakery, movie theater or drugstores, places that you go out and about. It's an integration statute. So if you're just watching in your house, that's not a place of public accommodation. And then, again, going back to the first point, which is, it was a bricks and mortar argument. Unfortunately, there are cases that have held that a place of public accommodation is bricks and mortar. There were a lot in the briefs about, well, there's all these enumerated categories. Why isn't the internet in that? And who wants to answer that question? The ADA was, I'm going to give a big hint. The ADA was passed in 1990. So who wants to answer the question of why the internet wasn't listed as one of the public accommodations? Someone must be wanting to talk at this point in the day.
It wasn't widely used. It existed, but it wasn't widely used.
I mean, it existed not really for home use. It existed in the, the computer would be maybe half of this room. I mean, it was very much in its infancy stages. I actually have some really amusing clips from the Today Show where they're going like, what is this, with the circle and it's very, very new. It's just been introduced. People on the Today Show in 1990 are laughing because they can't even imagine how this thing is going to be useful. So we never, I was able to be there at that time in the negotiations on the ADA. Believe me, no one ever mentioned the word internet. So our arguments back on Netflix was, first of all, it wasn't contemplated in 1990. No one had home computers. It wasn't used. Many of the activities, and if you go through the list of public accommodations, many of the activities that are listed, in fact, I'd say all of them, pretty much, even visiting a zoo, are now taking place on the internet. So we argued that this is we got to get to the letter, but also the spirit of the ADA. The spirit of the ADA is to have same opportunities and experiences of people who do not have disabilities. So much happens on the internet, and I don't think I need to convince anyone here of that. We said that, you know, it's not just like Netflix is, they're like, you know, passing through a good. Like you go to a bookstore. The bookstore owner is not responsible for having every single solitary book in Braille. We said, and there's an exception in the ADA for that. We said this isn't just passing through a good. What are they advertising? They're advertising a service that they can do it any place, anywhere. So we had to argue, we argued that integration is still implicated because people watch, and many of our plaintiffs, we had many plaintiffs in that case, as well as the National Association for the Deaf, that talked about, you know, I can't answer the questions that my little kids are asking me, like, you know, Mom, what just happened on the show? And I'm like, I can't help them because I, the deaf parent, don't have the captions. And what we were able to use in our case, and which is always the best thing to use, is Netflix's own words. Netflix, watch what you want, when you want, by streaming instantly over the internet, right to your TV, and then this is the picture of, is it an isolated example? This is just taken right from their website. Look at everyone all cuddled up together watching Netflix and choosing the movies, et cetera. And we had, again, plaintiffs who said, well, I'd love to do that, but I can't enjoy with my family because I'm deaf or hard of hearing, and I need captions. And then in terms of not just being in your home, we also had to go no further than their own website to show, you know, students viewing shows on Netflix as they're commuting somewhere. So the argument that it's just an isolated example, it doesn't really fit in with the spirit of the ADA because it's a private activity, really we had nothing, we had to go no further than Netflix's own website. And of course this confirms with all of your experiences. The Netflix decision, and I will make all these slides available, I think, through 3Play. But basically what the Netflix decision says is that it would be irrational to conclude that places of public accommodation are limited to actual physical structures. In a society in which business is increasingly conducted online, excluding businesses that sell services through the internet from the ADA would run afoul of the purpose of the ADA and would severely frustrate Congress's intent that individuals with disabilities fully enjoy the goods, services, privileges, and advantages available indiscriminately to other members of the general public. So basically it was the judge who, you know, again, we had to, you know, appear before the judge. This was not something that was just settled. Listened to the arguments, looked at the language of the ADA, but looked at the purpose of the ADA, and, you know, wrote what he wrote, which is that it's just irrational to assume that we're not going to have, that the internet, where so much commerce and so much entertainment and so much education takes place, is not going to be covered by the ADA, and yet still fulfill the goals of the ADA. And then he went on to say, the fact that it does not include web-based services as a specific example of a public accommodation is irrelevant, since such web-based services did not exist when the ADA was passed in 1990, and because, and this was a really good thing to put in the legislative history, the ADA makes clear that Congress intended the ADA to adapt to changes in technology. And even now, you know, as we think we've come the whole way, the whole distance, but we try to put in our settlement agreements that we're still looking for the changes in technology, because when Ken has perfected auto captioning, boy, life is going to be so much easier. After the decision by the judge, Netflix, we entered into an agreement, and our way of doing agreements in the area of captions is, the principle is that everything has to be captioned. which is why I asked you if everything was captioned. All your courses are captioned. That's how we see the world. Everything needs to be captioned. We understand that there are times when there's a big, big, big library of legacy content, and it's going to take some time. And so we're always interested in the principle of full captioning, but we understand that for legacy content, there might need to be a schedule created. How many of you are aware of what happened at UC Berkeley? Do one of you want to say, or do you want me to say? Because it looks like you're more familiar with it. Well, UC Berkeley, a complaint was brought about UC Berkeley having a lot of content online, and it needed to be captioned in order to be available to people with disabilities. And UC Berkeley took the step of removing a ton of material from the internet in response, partially, to this complaint. And it really sent like shockwaves throughout the community and throughout the nation and throughout the people in Berkeley who have, and I teach at Berkeley, who have great pride in Berkeley as being the center for disability, the home of disability rights, and the university's reaction, which was to remove content, we felt was a very, very, very negative statement to make to the students and to the community. And it is now touted all over the country as, well, we'll just get rid of the content then. And I know that from my point of view, as both a lawyer, but also as a user of captions, and also just a person who is a, kind of dyed-in-the-wool lefty, like First Amendment, all that, I mean, I think that's a terrible, terrible response, which is removing content. Now, part of why they remove content is because there's a lot of junk up there. There's a lot of courses that aren't updated, where the materials aren't available, where no one watches them. Well, then do that cleanup anyway. If you have a lot, I think there's a little bit of a game with the universities from what we can gather is that, how many courses do we have online? But a lot of the courses are, they're kind of junky. They're not really watched. They're not really complete. Well, then take them down for that reason. But using captioning as a reason is, it's a very sinister response. Anyway, since in the entertainment field, since we did the Netflix settlement, and that was after going to court, we were able to get settlements with Hulu and Vudu and Amazon and GoGo on the plane, and a great collaboration with Apple iTunes. And those are just my cases, our cases at Disability Rights Education Defense Fund with NAD. There's many others as well. So education institutions, I kind of jumped ahead when I started talking about UC Berkeley, but basically you all know about MOOCs. Let me ask this, does anyone doesn't know about MOOCs? No. So that was another big advent. It was kind of like, to me, it was like Netflix coming on board and saying, wow, you can get all this entertainment in your home. Well, now it's like you can get all this education in your home. And that's fantastic for a lot of people for a lot of reasons. So the MOOCs revolutionized education. And if you look at looking at the universities, their own words, they're the first ones that are going to talk about how it revolutionized education, how they get millions of viewers, how the top, most elite universities like Harvard and MIT now have their incredible knowledge available to the world. There's a lot of touting of it. And basically, when we bring these cases, and again, we always try to settle first, when we bring these cases, as we have in our office against MIT and the accompanying cases, Harvard, which we're actually not on, again, on behalf of NAD and individual plaintiffs, we're bringing those cases because we're saying, all that wonderful touting of how fantastic it is, well, it's the public. Well, we're part of the public too. people who require captions in order to access this are part of the public. It's kind of a simple proposition if you look at it that way. What we do, the reason at DREDF anyway, when we're looking at a field and how to make it accessible, what we try to do is identify who are the leaders in that field. At the time we sued Netflix, they were like, I don't remember, but something like at least 80, maybe 90% of the market share. So if you're going to bring a lawsuit, which takes a lot of time and energy and resources, it's good to go to the leader of the industry. And same thing with the education cases. The cases have been brought after trying to settle with MIT and Harvard because they're the top of the line and they're offering content that how many people around the world would love to take a course offered only at MIT or Harvard. So we also failed in negotiations there. And a lot of the issues I can't really discuss at this point because it's an ongoing case. But again, I think that part of, I love like the 3-plate slide about how many students prefer captioning. I think we really need to do a really good job. I actually wrote Ken recently asking like, where are all the studies about how great captions are for everyone? I think that the learning tool, that is a learning tool for everyone, especially in these courses, if only we could communicate that in a way that was believed, because that's not how it's received. We're still talking about something as though we're asking for something extraordinary. And besides the technology being available to provide captions, it's also just a mindset of people who are deaf and hard of hearing can't access the material, period, without captions. But also so many other people benefit as well. Again, this is the complaint. What I mean by complaint is the complaint we filed in court. And again, we really capitalize on the words that they use about how these are widely available to everyone, available for anyone with access to the internet. There's all this kind of wording in all these courses. And as one of the 48 million people who are deaf or hard of hearing, I'm like, well, that they're not available to anyone who has access to the internet if they don't have captions. So we had a Harvard and MIT file very, very aggressive motions to dismiss the lawsuit on a whole basis of grounds. Like it would infringe upon free speech if there were captions. Like you can't impose captions upon people who want to have free speech. Things that really, the whole concept of it just shows how really far away we are from understanding that it's just part and parcel with speech. It's not we're not changing, the whole idea of captions is that you're not changing the words. That's the worst thing you can do with captions. You're keeping the words. You're just making them available to everyone. We were able to defeat the motion to dismiss. It was like a 50-page decision going through each of these arguments. Just a matter of contracting. So recently there was a whole slew of cases in New York, and the list I have here is pretty illustrative. It's not meant to be exhaustive at all, but there were the first case that actually went through trial is Winn-Dixie, and people want to, now people do their groceries online. There's nothing that isn't done online, and if you're going to have, this case happened to involve blind access. And same thing with Blick Art Supplies. Most of the cases, again, some great language from Judge Weinstein about, which says that basically the ADA was intended to emancipate the disabled from the bounds of isolation and segregation, obsolete when its objectives is increasingly within reach. So again, the courts are getting that the purpose of the ADA is equal opportunity. There's means to provide equal opportunity. And unless there's a defense, and the defenses in the ADA are the same as 504, which is either undue burden, or, which is pretty much a money defense, it can be administrative defense, or fundamental alteration. That by requiring us to do something, you're changing the whole nature of what we do. Again, if you're going up against Harvard or MIT, Harvard, I'm pretty sure they have an $38 billion endowment. I don't know what kind of dent captions would make in that, but we're hoping we could get through that one. And other areas where it's being applied is healthcare. There's a lot of healthcare videos that are now online. A client we had actually was watching a video about giving birth while she was giving birth, except that she couldn't understand it because she was deaf. Transportation. We have a lot of issues with kiosks, and this again blind issues. Public benefits are now increasingly done online, and we have several cases with public benefits. We have Social Security Administration, we have CMS for Medicaid and Medicare, financial institutions, banking, and I also am providing on this slide some sources where you can see like the range of cases that have been brought. And the idea of all of them is the same, which is to think positively in terms of access, to know that it opens up the world for so many people. And it happens that it benefits a lot of people who are not deaf and hard of hearing as well. It's great for business. It's the right direction to go in. The people like me who are plaintiff's attorneys, I'm a zealot, but I hope to be not that unreasonable in terms of hearing legitimate concerns. But sometimes you just, if you just hit a brick wall at this stage, it's very, very frustrating because the means are there. We do not usually pick on people who do not have the means to do it, and it's a better world for everyone when there's more access. Thank you.
Thank you so much, Arlene.
Did that go over?
Yes.
By a lot?
No, you didn't go over at all.
Oh, okay, good.
And I hope that everyone will join us for a happy hour. We have drinks and refreshments and snacks, and we'll look forward to talking to you. Thank you all so
What
much
about
for being
questions?
here. If anyone has questions, please come up and ask Arlene. Thank you.